Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, take this opportunity to welcome those who are joining us on our heritage.org website, those who are also joining us on C-SPAN this afternoon. We would ask everyone in-house to make sure your cell phones have been turned off for all of the recordings going on. We will post the program within 24 hours on the Heritage homepage for everyone's future reference. And our internet viewers and television viewers are always welcome to send questions simply emailing us at speaker@heritage.org. Hosting our discussion and introducing our special guest today is the Ronald Reagan Distinguished Fellow Emeritus here at the Heritage Foundation, also the 75th Attorney General of the United States, Edwin Meese. Mr. Meese?
Thank you, ladies and gentlemen, and I join John in welcoming you here to this lecture this evening, which, as you know, the Joseph Story Lecture, as those who are familiar with legal history know, is named in honor of a distinguished judge who epitomized faithfulness to the Constitution. And this lecture is part of a series that we've had here in our Preserving the Constitution series, and marks a very important part in that series, obviously. Well, in November of 1811, at the age of 32, Joseph Story became the youngest justice appointed to the United States Supreme Court. He served in that capacity from 1811 to 1845. He is perhaps best remembered for his magisterial commentary on the Constitution of the United States, which was first published in 1833. This work is met by many experts in the field, is marked as literally the cornerstone of early American jurisprudence. It was the first comprehensive treatise on the provisions of the United States Constitution and remains a critical source of historical material about the forming of the American Republic, and particularly that novel idea that the founders put together in our Constitution, and that was an independent judiciary, and particularly the Supreme Court. Joseph Story was known as a statesman of the old republic in the sense that he was one who did much to shape the concepts, the ideas, in accordance with the ideas of the founders, as they looked for our Constitution and how it should be utilized and interpreted, and how it should become the foremost basis upon which the courts should make their decisions. And of course, that continues to be something very important to us here at Heritage. Story was active not only as a justice, but literally as a pillar of the legal profession. He was, even while sitting on the Supreme Court, he became a professor of law at Harvard. He also was a prolific writer, writing many law review, or what passed as law reviews in those days, magazine articles and the like. He also was a frequent orator on patriotic occasions and other public events, and also published a variety of books on a whole series of subjects relating to the law. His books were recognized even in those early days, both in the United States and also internationally. Well, like Justice Story, our speaker tonight has demonstrated throughout his career his fidelity to the Constitution, I might say, in a circuit that frequently has had need of such guidance. As a judge on the U.S. Court of Appeals for the Ninth Circuit, Judge O'Scannlain has participated in over 10,000 federal cases and has written hundreds of published opinions on a broad range of subjects. One of his particular subjects on which he is expert is, of course, constitutional law, which makes him a logical speaker here at the Story Lecture. He's also worked in a number of ways to further the cause of justice. The late Chief Justice Rehnquist appointed him as chairman of the Federal Judicial Center's Advisory Committee on Appellate Judge Education. Chief Justice Roberts more recently has appointed him to the International Judicial Relations Committee of the United States Judicial Conference, and subsequently appointed him as chairman of that body, which is very critical in bridging the gap between the United States and other countries in the discussion of the judiciary and constitutional matters. His professional interests also include judicial administration and reform, and particularly legal education. He has been chair of the Judicial Division of the American Bar Association. He's chaired the ABA's Appellate Judges Conference and their Committee on Appellate Practice. He's also an adjunct professor at the Lewis and Clark Law School and has been a moot court judge throughout the country in a number of distinguished law schools. He's retired from the United States Army Reserve, where he served for a number of years, 23 years, I believe, in the JAG Corps, and worked in both the Army Reserve and the National Guard. Judge O'Scannlain and his wife, Maura, who is with us here tonight, have 8 children and 18 grandchildren. So he is literally helping to carry on the spirit of constitutional fidelity. Ladies and gentlemen, an outstanding speaker, truly worthy for his fine work as a judge and as a defender of the Constitution, Judge O'Scannlain.
Thank you very, very much.
Thank you for that very kind introduction, Ed. It is a singular honor to be delivering the Joseph Story Lecture here at the Heritage Foundation, and your presence here tonight makes this honor all the more meaningful to me. For those of us who believe that judges are required to enforce the original meaning of the Constitution, General Meese is a real hero. Not only was Ed instrumental in the appointment of judges who value the original meaning of the Constitution, but he also made the case for this interpretive approach in high-profile speeches during his time as Attorney General of the United States. Those speeches had a tremendous impact on the legal culture, and it is fair to say that without Ed Meese, the effort to restore the original meaning of the Constitution would not have been nearly as successful as it has been. For that, all of us owe Ed a debt of gratitude. The name of this lecture carries with it a great legacy. Through opinions and essays, through commentaries and treatises, Justice Joseph Story's influence continues to resound through American legal thought, and rightly so. His breadth of knowledge was extraordinary, spanning subjects as varied as promissory notes, constitutional law, and even natural law. James McClellan, a legal scholar associated with Russell Kirk, once said that Story's work on natural law stands out like a ray of light in the midnight hour of American political theory. Indeed, it is Story's natural law philosophy that I wish to focus on this evening. A comprehensive analysis of Story's jurisprudence is, of course, far beyond the scope of this lecture. Rather, I offer a sketch of his views on the natural law with the modest goal of showing how some of his insights might bear on a few of today's most hotly contested legal disputes. My analysis of Story's natural law philosophy must begin by acknowledging the limits of my inquiry. To speak of Story's philosophy is to imply that Story had a consistent, coherent understanding of natural law. But the truth is that there was a good deal of confusion about natural law in the late 18th and early 19th centuries. The natural rights theory of John Locke and other Enlightenment thinkers was often unwittingly conflated with the natural law theory offered by philosophers like Thomas Aquinas. And Story himself was guilty of this confusion on occasion. Fortunately, however, we need not detain ourselves with the differences between natural law and natural rights, because the aspects of stories philosophy that I wish to examine tend to parallel fairly well, albeit imperfectly, those of the classic natural law tradition. Let us begin then by examining Story's understanding of the relationship between natural law, the law that exists without any human author, and positive law, the kind of man-made law that Congress passes and that I interpret in my everyday role as a judge. In addition to being a justice of the Supreme Court, Story, as you heard, was one of the great legal scholars of his day. He was a chaired professor at my alma mater, the Harvard Law School, and it was as a professor that Story produced his famous Commentaries on the Constitution, which served as the textbook for his course on constitutional law. Given Story's extensive body of scholarship, it is unsurprising that he penned an encyclopedia entry on natural law, which appeared in Francis Lieber's Encyclopedia Americanae. This encyclopedia essay remains Story's most complete exposition of his views on natural law, and so it is appropriate that we focus our examination of Story's philosophy there. Story's essay opens by defining natural law as that system of principles which human reason has discovered to regulate the conduct of man in all his various relations. Let me reread his definition. Natural law is that system of principles which human reason has discovered to regulate the conduct of man in all his various relations. Immediately, we should notice that Story sees natural law as something pertaining to reason, to use the words of Aquinas. It is something we can all access through reason rather than something known only by revelation. But unlike the laws that are passed by Congress, natural law does not change. Story says that God has fixed the laws of mankind's being and has the supreme right to prescribe the rules to which man shall regulate his conduct. Again, we see the agreement between Story and Aquinas, who wrote that the natural law is altogether unchangeable in its first principles. It is important for us to pause here and to understand that the natural law applies to man because of the nature of man, and that natural law thinkers, including Story, believe that man's nature is, in important respects, inherent and unchangeable. This is critical to grasping why it has been said that the natural law is universally binding on mankind. Indeed, our Declaration of Independence explicitly assumes a fixed human nature from which we can derive certain principles. The Declaration says that we are endowed by our Creator with certain unalienable rights, such as life, liberty, and the pursuit of happiness. But those rights derive from the premise that all men are created equal. In other words, it is only because of the nature of man, our fundamental equal dignity, that certain principles are binding upon all mankind. These conclusions lead directly into Story's account of man-made law, sometimes called positive law. In classic natural law theory, positive law is derived from and implements the natural law. As the Reverend Martin Luther King, Jr. explained in his letter from a Birmingham jail, to the extent that a positive law conflicts with natural law, there is no obligation to obey such a law because, in the words of Augustine, it is no law at all. Now, Story was in agreement with Dr. King's description of the relationship between natural and positive law and uses the example of marriage to illustrate his view. He observes that marriage arises from the law of nature because it channels otherwise dangerous sexual appetites toward the mutual good of the spouses and the responsible procreation and rearing of children. From these premises, Story concludes, if marriage be an institution derived from the law of nature, then whatever has a natural tendency to discourage it or to destroy its value is by the same law prohibited. In other words, Story believed that positive law must conform to natural law. Remarkably, for Justice Joseph Story, as for other classic natural law thinkers, positive law that conflicts with natural law is not law at all. Having examined Story's general philosophical framework, let us see how he applied his view in concrete cases. In the 1822 Admiralty case, La Jeune Eugénie, an American public armed vessel seized an allegedly French ship that is suspected of engaging in the trafficking of slaves. The American captain asserted that the trafficking of slaves from Africa to a foreign port violated the law of nations, and therefore the confiscation of the ship was the appropriate penalty. Story's opinion begins by claiming that the law of nations rests on the eternal law of nature. The law of nature, he said, is deduced by correct reasoning from the rights and duties of nations and the nature of moral obligation. Natural law for Story is the basis for the law of nations. However, Story is careful to note that he, as a judge, only has the authority to enforce the law of nations if it has not been relaxed or waived by the consent of nations, as seen in their general practices and customs. Indeed, Story was willing to enforce the Fugitive Slave Act of 1793 in his opinion in Prigg versus Pennsylvania, despite his strong view that slavery was inherently unjust. Thus, even Story, an ardent proponent of the natural law, recognized that the judicial office placed limits on his ability to apply natural law. In another setting, I have expressed a similar view about the power of the American judiciary to enforce natural law, but I will leave that issue to one side for our purposes this evening. Turning to the practice of slave trafficking, Story writes that, and I quote, "It cannot admit of serious question that such exploitation is founded in a violation of some of the first principles which ought to govern nations. It is repugnant to the great principles of Christian duty, the dictates of natural religion, the obligations of good faith and morality, and the eternal maxims of social justice." And here is the key line. When any trade can be truly said to have these ingredients, it is impossible that it can be consistent with any system of law that purports to rest on the authority or of reason or revelation, end quote. Now remember that Story believes that positive law is the only law insofar as it conforms to natural law, and natural law is derived from reason. Having concluded that natural law prohibits slave trafficking, Story explains that no system of law that purports to be based on reason can sanction such activity. Therefore, Story writes, it is sufficient to stamp any trade as interdicted by public law when it can be justly affirmed that it is repugnant to the general principles of justice and humanity. And so the court held in that Admiralty case that slave trafficking violated the law of nations, and it refused to order return of the vessel to its owners. Nevertheless, for reasons of comity, the court did hand the vessel over to the French consul, despite the court's skepticism about the true nationality of the ship. Story's interpretation and application of the natural law was thus decisive to the outcome of that case. Several salient features of Story's natural law philosophy stand out in the opinion. In the primacy of natural law over positive law, it is prominent, as is the idea that the natural law is rooted in the common nature of man, such that the natural law is universal to all mankind. We will revisit these themes later, but first let me examine Story's philosophy of positive law. As many of you know, Story was a self-proclaimed disciple of Edmund Burke. Like Burke, Story emphasized the importance of tradition and experience in the formulation of positive law. It was Burke who said, "We are afraid to put men to live and to trade on his own private stock of reason because we suspect that this stock in each man is small, and that the individual would do better to avail themselves of the general bank and capital of nations and of ages." When he surveyed the list of men in the National Assembly at the start of the French Revolution, Burke observed that the best were only men of theory, lacking in all practical experience. As Burke put it, "From the moment I read the list, I saw distinctly and very nearly as it actually happened, all that was to follow." In Burke's view, the chaos and barbarism of the French Revolution, so chillingly depicted by Charles Dickens in A Tale of Two Cities, was a direct result of the Revolution's attempt to divorce itself from France's history, customs, and experience. Burke's emphasis on experience and tradition derived from his understanding of human nature. He believed that the nature of man is intricate and that no simple disposition or direction of power can be suitable either to man's nature or to the quality of his affairs. Therefore, a deep knowledge of human nature, he said, was required of statesmen, and history and traditions are the best way of knowing what institutions and laws are best suited to human nature. Now, Joseph Story was of the same mind. In the introduction to his commentaries on the Constitution, Story wrote, "A constitution of government is addressed to the common sense of the people, and never was designed for trials of logical skill or visionary speculation." He believed it was essential for any public official to distrust the theory and cling to practical good, to rely more on experience than reasoning, more upon institutions than laws, more upon checks to vice than upon motives to virtue. It is quite clear then that Story embraced Burke's approach to government and lawmaking, one that prizes experience and tradition over theory and novelty. This Burkean theory of lawmaking accords with Story's views of natural law. As Professors Robert George and Russell Hittinger have reminded us, natural law theory distinguishes between two kinds of positive law: those that follow as logical conclusions from natural law, such as the laws against homicide, and those that are not required by natural law, but are consistent with it. These latter types of laws are called determinationes, and they include laws like the one requiring drivers to drive on the right side of the road. Hittinger estimates that the vast majority of positive laws are determinationes. They require lawmakers to make practical judgments about the best way to achieve some end, rather than deducing these laws directly from natural law principles. Thus, determinationes derive their binding nature from the fact that they were promulgated by a recognized, competent legal authority rather than being compelled by the natural law. Aquinas says that in the creation of determinationes, lawmakers should follow Aristotle's advice and pay as much attention to the undemonstrated sayings and opinions of persons who surpass us in experience, age, and prudence as to their demonstrations. Aristotle argued that law has no power to command obedience except that of habit, and so laws should not be lightly changed. Justinian's Digest incorporates this view of positive law when discussing the enactments of emperors, cautioning that new laws must have some clear advantage in view, such as to justify departing from a rule of law which has seemed fair since time immemorial. So then, Story's natural law philosophy fits comfortably with his Burkean approach to positive law. The crucial point of similarity between these two theories is this: both assume that mankind has a fixed nature. The modern idea of a malleable and socially constructed human nature is alien to Burke and Aquinas, and therefore is alien to Story. And, as we will now see, Story's view of man's nature was cast aside by our own Supreme Court as it exited the 20th century and entered the 21st. How different our constitutional jurisprudence would be today had this not been so. In the 1992 abortion case, Planned Parenthood versus Casey, the plurality opinion famously, or perhaps for some infamously, asserted the following: at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under the compulsion of the state. This statement, which Justice Scalia has called Casey's sweet mystery of life passage, has been much criticized. Indeed, Professor Hittinger has said, this right, so-called, could mean virtually anything. But regardless of whether one believes that the passage is banal, its fundamental philosophical premise is clear. The law cannot assume that human nature has an objective reality. The passage does not necessarily deny that there is an objective human nature, but it insists that the law cannot reflect a particular conception of human nature. As the Casey passage says, each of us is to decide for ourselves what defines our existence, and the mystery of life. Story, by contrast, believed that man's nature gave rise to specific institutions, duties, and principles of morality that can be embodied in law. Whereas Story's natural law philosophy appeals to truths that transcend the individual, Casey's dictum presumes an autonomy of self that makes the individual the sole arbiter of what is true. Moreover, it is important to understand that this passage makes a claim about the nature of liberty and rights. It purports to be construing Supreme Court precedent, but its language is far broader, and its theoretical implications are far more ambitious than the court's canonical descriptions of liberty had been prior to Casey. Its implications are profound, because if the law cannot protect an objective view of human nature, it necessarily protects a subjective one. Casey thus places a malleable conception of human nature at the heart of the liberty protected by our Constitution. This view of liberty is also found in the court's 2003 decision in Lawrence versus Texas, which struck down a Texas criminal prohibition on homosexual sodomy. Lawrence stated that liberty, as a general rule, should counsel against attempts by the state or a court to define the meaning of the relationship or set its boundaries absent injury to a person or abuse of an institution the law protects. In doing so, it discounted the significance of history predating the sexual revolution, as when the court said, "We think that our laws and traditions in the past half century are of the most relevance here." All this is quite consistent with Casey's relativism. After all, human nature serves as the basis for human relationships and sexuality, and a subjective view of the former will lead inexorably to a subjective view of the latter. It was no accident that the example Story chose to illustrate the connection between natural law and positive law was marriage. Story's belief in a fixed human nature logically entailed a fixed conception of marriage. Having adopted the subjectivist assumptions of Casey, Lawrence extends them to protect a relativistic conception of human sexuality. And now comes United States versus Windsor this past term. Windsor invalidated the section of the Defense of Marriage Act that defined marriage as the union between a man and a woman for purposes of federal law, a definition that accords with what I would call the conjugal view of marriage. Commentators have noted that it is difficult to determine the precise rationale of Windsor, a confusion reflected in the contrast between Chief Justice Roberts' characterization of Windsor as a federalism decision and Justice Scalia's view that Windsor inevitably will lead to the invalidation of state conjugal marriage laws. Notable scholars such as Professor Hadley Arkus interpret Windsor as standing for the proposition that the conjugal definition of marriage is per se irrational. And as Justice Alito's dissent in that case pointed out, supporters of DOMA, who sounded very much like Joseph Story, argued that there are unchangeable truths about human nature that have implications for sexuality and mandate the conjugal definition of marriage. This argument has been most prominently advanced by Professors George Sharif Girgis and Ryan Anderson in their recent book, what is marriage. Now, if Windsor rejects the conjugal definition, and I'm not saying so that it does as a legal matter, that's a separate issue, then it does so on the basis that there is no objective reality to what marriage is. The opinion repeatedly implies that marriage is not a pre-political institution arising from the law of nature. To use Story's words, but is instead subject to change by the state. For instance, Windsor says that the conjugal view has been discarded by some states in favor of a new perspective, a new insight, and that these states have enlarged the definition of marriage. But if marriage has a fixed meaning derived from man's nature, then it cannot be enlarged. If my friend Professor Arcus is right about the scope of Windsor's holding, then our constitutional jurisprudence not only protects a relativistic conception of marriage, it affirmatively declares that there is no objective reality to marriage and that any contrary view is irrational. This goes a long way toward ultimately declaring that the objective view of human nature is itself devoid of reason. By now, it should be quite apparent to all of us that there is a great chasm between Justice Story's philosophy and that of recent Supreme Court cases. Before I elaborate on this point, I want to note briefly that my discussion of these cases is focused on their philosophical assumptions, not on their holdings. I take no position here about the scope of those cases or their application to future ones. I only wish to describe the deep tension that exists between the philosophy undergirding decisions like Lawrence and Windsor on the one hand, and Justice Story's on the other. That tension is manifested in numerous ways. Most fundamentally, Story would have disagreed with the relativistic assumptions of Casey, Lawrence, and Windsor, because it is precisely man's fixed nature that makes the natural law universally applicable, as our own Declaration of Independence makes clear. Go back to Story's opinion in La Jeune Eugénie, in which he declares slave trafficking to be repugnant to the eternal maxims of social justice based on the natural law philosophy. If there are universal principles of justice, as Story believed there were, then those universal principles must exist by virtue of what it means to be a human being. And if there is no such thing as a stable human nature, then there can be no such universal principles. And without universal principles, it makes no sense to speak, as Windsor does, of the need to protect personhood and dignity, since these words appeal to concepts inherent in all humans. From Story's perspective, the court's recent jurisprudence is at war with itself. It purports to protect universal principles of justice, yet its assumptions undercut the very idea of universal principles. Story would also object to the willingness of these decisions to depart from history and tradition, which he regarded as essential guides for positive law. You'll remember that Lawrence was content to minimize the importance of pre-sexual revolution history. Windsor, after acknowledging that the conjugal definition of marriage has existed literally throughout the history of civilization, minimizes this highly significant fact in order to discuss the new perspective of same-sex marriage. When one reads these passages, one is confident that Story would reiterate his warning, and I quote, "The rage of theorists to make constitutions a vehicle for the conveyance of their own crude and visionary aphorisms of government requires to be guarded against with the most unceasing vigilance," unquote. Story might say that the vigilance he urged has been replaced by the philosophical blindness of abstract theory, detached from experience, tradition, and the very nature of man. As a Burkean, Story probably would not have been surprised by the court's tendency, like all human institutions, to fall into what he perceived to be grave error. But from Story's perspective, the damage these cases have done to the law, however predictable, is compounded by their source. Story's faith in the law stemmed from his belief that the common law tradition was the just application of principles to the actual concerns of life. It is one thing for a legislator who is buffeted by the tumultuous winds of politics and self-interest to warp the positive law. It is quite another for a judge who is deliberately insulated from such concerns to break the union of natural and positive law. The former is an example of reason obscured, the latter an example of reason ignored. Allow me to conclude with this thought. In one of the most powerful passages in Burke's Reflections, he assails the French revolutionaries for their disregard of their own history. He sketches for them an image of the future they might have had, harvesting the wisdom of their ancestors to produce a future worthy of their ideals. As Burke said, respecting your forefathers, you would have been taught to respect yourselves. But they had not chosen that path. Instead, their extravagant and presumptuous speculations, in Burke's words, led them to despise all their predecessors and all their contemporaries, and even to despise themselves until the moment in which they became truly despicable. Burke believed that we are constituted by our past, and by destroying their past, the French had destroyed themselves. Justice Joseph Story poses a similar challenge to us. We must ask whether the denial of our past is a denial of ourselves. We must ask whether the abolition of nature is the abolition of man. I leave the answers to these questions to your own reflections. Thank you very much.
Judge, I think that expression by the audience here reflects the quality of that excellent talk today. What I would consider a critical part of the kinds of things that the freedom-based legal scholars that are here for their conference at the present time have been fighting for, and which gives us a firm basis to look at constitutional history in the future, and the hope that this will perhaps be persuasive to more of your colleagues in the judiciary in the United States. It's now time to turn to the audience and to open it up to your questions, and if you'll resume the platform
Certainly.
here, we'll ask for the first question. Yes, Manny? Would you wait for the microphone and then just give your name and? Sure.
Manny Klausner from Los Angeles Reason Foundation and Individual Rights Foundation. My question for the judge is, looking forward or looking backwards on your own career as a judge, are there any particular opinions that you take greatest pride in, or any that you'd like to call to our attention tonight?
I suppose the first opinion that would come to mind would be Coalition of Equality versus Wilson. That was the Prop 209 case in which the voters of the state of California voted by a very substantial margin, I think 61 to 39, something like that, to eliminate preferences in state employment and state contracting based on race and other considerations. That case came up through my court, the Ninth Circuit Court of Appeals, and we determined that the proposition was constitutional, almost an inculcation of the Equal Protection Clause. There's some interesting language in that case. Many of you could probably recite parts of it, I don't know. But I certainly remember that case very, very well. I'm always reluctant to be too specific about cases because there are a lot of collateral issues and aspects that surround them, but that's certainly one I remember very well.
John Eastman.
Judge, thanks so much for a brilliant talk. You mentioned that Story himself thought that he couldn't enforce the natural law at times, but that other times he used it to apply his jurisprudence. How did he negotiate that line, and how do you?
Well, I think, if you recall that passage in La Jeune Eugénie, he identifies that the law of nations is built upon the natural law, and then he has that exclusion. He says that except to the extent that it is in effect been modified by consent of nations, or when we're in that situation where it has been modified by the consent of nations, then you follow the law identified by that enactment. And that's obviously the same way I approach things. There are laws which I come across quite frequently with which I disagree. I'm not entirely sure that they're based on what I would believe to be supportable premises, but they're binding on me as a federal judge, and it's my job to enforce that law as it has been duly written by the Congress, assuming it's a federal law, and to carry it out. That's the brilliant solution that I think we have in terms of our own system of checks and balances. And as Burke pointed out, legislators can make mistakes, and it is not up, in my personal view, it's not up to me to correct the mistakes of legislators. I have to follow the positive law and comply with it.
Roger.
Judge O'Scannlain, I'm Roger Pilon with the Cato Institute. Let me pose a critical but not a hostile question.
Okay. All right.
First of all, I want to commend you for taking on this subject seriously of the natural law. Too few judges do, and it's to your credit that you have done so. I also want to then go back to the distinction you drew at the outset between the natural rights tradition and the natural law tradition, and say that I'm with you on Casey, but not on Lawrence, and here's why. You have spoken of an objective conception of man, and I fully agree with that as the starting point. But I wonder if you have not packed into it more than you can without facing circularity. And it has to do with the fundamental and ancient distinction between the right and the good. The Declaration of Independence speaks of the right to pursue happiness. Well, what makes you happy may not be necessarily what makes me happy. We have subjective values and objective rights, and that's how it is that one can distinguish between cases like Casey and Lawrence. Lawrence, let's remember, was justified in the name of dignity, the liberty to pursue your own conception of what is right or good for you, even as you respect the equal rights of others to do the same. So I wonder if you would care to respond to that line of argument.
Well, I'll accept that as fair comment. And I think that there will be times when these principles start to collide. I was comfortable with what I said about Lawrence because I felt very troubled by the fact that Lawrence was decided pretty much on the basis of a case decided in the European Court of Human Rights. I didn't think that that's where we should go to interpret our own Constitution. But I think that reasonable persons will differ when it comes to applying some of these principles, and it could very well be that Lawrence is right on the cusp. If you can accept that as a response, I think that's as much as I can say.
Alder?
Walter Weber with the American Center for Law and Justice. Again, thank you, Judge, for your talk. One of the dangers that I see in the mystery of life approach, it's not unique to that, is that when you have a standard that is sufficiently broad and subjective like that, while it purports to empower the liberty of individuals, I suspect that what it really does is aggrandize the power of judges. Because in almost any other context outside abortion and sexual revolution-related cases, those arguments would not go anywhere. And I think that same criticism might apply to things like the endorsement test, which ultimately empowers judges to decide what is or is not a reasonable observer's opinion on religion questions. Is your sense that I mean, this is kind of a psychological question, the judges that adopt these positions, I assume, are not viewing this as attempts to institutional aggrandizement, but rather to adopt liberty for people. But I wonder if it crosses their mind the fact that they are the institution that will decide which liberties count, which ones are important, and which ones are not. So it ends up being only those liberties that the judges decide are worth putting on this extra higher level, as opposed to being, yes, we really are going to let everyone decide for themselves the meaning of the mystery of human life.
I'm not quite sure what the question to me is. In the DOMA cases, of course, Congress elected a determination of what it perceived to be consistent with the Constitution. And obviously, there was a split of opinion on the Supreme Court, with strong opinions going different directions. Again, I apologize for not quite locking onto the essence of your question, but can you help me a little more, or have I said enough?
I guess I was asking if you agree that there's a danger with these kinds of popular tests that they ultimately empower the judiciary.
I'm sorry, of course. So I think that, and frankly, I blame the legislative branch in many respects. So often we get cases that require us to interpret statutes that are purposely vague because the members of the legislature, whether it's the Congress or a state legislature, couldn't get their act together and couldn't agree on something, so they said, all right, let's pass this bill and let the courts figure it out. I think that's irresponsible conduct on the part of the legislature. Of course, once we get it, then it's our job, and then I think it's very incumbent upon us to act, at least in my philosophical view, in a minimalist way. I don't take the position that we have this unbridled authority. I think our authority is limited by Article 3 and by the Judiciary Act and other constraints that are on us. So anything that does give courts this very wide latitude, I think I find uncomfortable.
Okay, and right here.
Hi, Andrew Cluster with the Heritage Foundation. Judge, and I think many folks are certainly troubled by a breakdown of education on what the content of the natural law is. So I was just wondering if you had some recommendations for folks as far as what sources they could go to maybe educate themselves or others about the natural law.
Well, the first thing I'd recommend is you read the Joseph Story entry in the encyclopedia. It's 4 pages long. It's a good start. I mentioned some authorities in my remarks. People like Robbie George at Princeton and Hadley Arcus at Amherst are writing in that area and have some good contemporary commentaries that will help you, and I commend them to you.
Yes.
David Burton with the Heritage Foundation. The framers were influenced by more than one philosophical tradition. They were influenced by the Lockean natural rights tradition, by the historical British tradition, the British Constitution, and the rights of Englishmen, as articulated by Burke, but also Blackstone, the Scottish Enlightenment and their natural law tradition, and also, to, I think, a lesser degree, the natural law tradition of Aquinas. So my question to you is, when interpreting the Constitution, since the framers were influenced by several different and occasionally conflicting traditions, how do you resolve the differences, and what role does the differences between the traditions play in assessing the original meaning of the Constitution?
Well, like Justice Clarence Thomas, I take the view that the Declaration of Independence has relevance to the interpretation of the Constitution. I know that's a controversial issue, that many of my colleagues would exclude the Declaration as not having anything to do with interpreting any of the Bill of Rights or whatever. And I take it from the description in the Declaration, some of which I quoted, that these are principles that have recognizable parentage. I derive from those passages the story view based on natural law heritage. But as again I mentioned in my remarks, there's natural law and there's natural rights. I think the overlap is probably 95%. I think the natural rights theory comes more from kind of a scientific approach that has been popular among many philosophers. I don't regard it as confrontational. I regard it as a very heavy overlap.
Take one more question. Back there.
Hi, I'm Ryan Anderson, also from the Heritage Foundation. I don't think we planned it that these last 3 questions would all be from Heritage Fellows, but I'm one of the co-authors of the What is Marriage book. Thank you for your kind words about it. I wonder if the problem didn't start earlier, if we go back before Casey to Griswold, because in your comments on Story, when he discusses what marriage is, why marriage matters, he then says that those actions that would detract from marriage would be contrary to the natural law. And in our constitutional regime, the states had the police powers to promote public health, safety, and morals. And that this wasn't viewed as subjective value preference, but as objective morality. And so the states were authorized to promote this. And so it looks like with Griswold, then with Roe, then with Casey, then with Lawrence, you get a train of court cases striking down the state's ability to promote public morality. And how has that contributed to the erosion of a healthy marriage culture and to a sound constitutional regime?
Well, that would take another 45-minute lecture, I think, to respond to. My purpose was to identify Justice Story's interest in and active involvement in natural law theory. Where we are today is a deeply cultural issue. The fundamental principle that I hold dear is that it's up to the legislature to make those shifts and turns and departures clearly and overtly, and not the job of the judiciary. The judiciary, in my view, ought to be the brake. It ought to be the guide that reminds everybody where we've come from, what the country was created to do and to mean, and to kind of take that stand back and look view rather than what is current or popular at the moment, because that's going to change, whereas the fundamental principles that we were originally founded on really should remain true.
Judge, thank you very much again. It is now my pleasant opportunity to present you with what we have developed here, again, as part of our Preserving the Constitution series, but particularly culminating in this lecture, our Defender of the Constitution Award. And we'd like you to take this back as a remembrance of how much we appreciate both the work you've done as a judge and also your excellent presentation this evening.
Thank you, Ed. I will treasure this. Thank you so much.
And also, this may be superfluous, but we happen to have the books here, which are commentaries on the Constitution of the United States by Joseph Story, as described and commented on by Thomas Cooley. You probably have them already in your library. Now you can have a set at home as well. And this was thought up by my colleagues at the Law Center. This was not my idea, but I certainly joined with it. This is a familiar exposition of the Constitution of the United States by Joseph Story, and it happens to have a foreword by me, which I want you to understand was not contemporaneous.
Thank you so much.
At this time, ladies and gentlemen, we invite you to the foyer, the Allison Foyer, where there will be a reception. You can personally meet the judge as well as gather and enjoy yourselves. So please join us at the reception now. Thank you for being with us tonight.